I'll call 121-865, State v. Strong.
Madam Chief Justice, Your Honors, and may it please the Court, my name is Hope Bathlick Reynolds. I appear on behalf of Shameke Strong. May I please reserve 3 minutes for rebuttal? Thank you. This case presents questions about the constitutionality of Kansas law, which mandates in certain prosecutions that a jury presume intent to distribute without proof provided by the state. I know this court is hearing several permutations of this issue on this docket, and so I'd like to focus first on the constitutionality of the statute and then turn to the permissibility of the instruction. The statute clearly requires that a jury presume or that a jury make a rebuttable presumption of intent to distribute if a person possesses certain quantities of controlled substances. To the extent there is a factual finding from the legislature and the legislature history in establishing those quantities, I am unaware of it. The law has clearly found that these rebuttable presumptions, mandatory presumptions, are impermissible for nearly 40 years under Francis versus Franklin. This court has found the same in Harkness and Allen. And Mr. Strong would ask that this court invalidate that statute as unconstitutional under those clear and long-standing cases.
Are you making a facial argument, or is this an as-applied? It seems to me more as an as-applied. Or explain to me where you're coming from with your analysis here.
Yes. In the briefing, it's presented as a facial challenge to the statute, Your Honor.
How do you have standing to do that?
So Mr. Strong has standing because the statute was the basis of the instruction number 6 provided in his case. That's clear based on the PIC notes on use in the instruction. It's also clear because the prosecutor during closing argument argued the statute. We've discussed in other cases prosecutorial error. That's not what we're arguing in this case, but that's how this court can get to the statute. The only reason the jury was instructed about an inference, a permissive inference, which is different from what the statute requires, is because of the statute.
Can you draw our attention to where, specifically, in the closing argument, the prosecutor referenced the statute?
Yes. So that is volume 4, pages 159 to 60 and page 168. And specifically, Your Honor, the prosecutor said, you have instruction 6 in this case, and it tells you you can presume a person that has 3.5 grams or more of methamphetamine, then they have the intent to distribute it. The prosecutor goes on to link the presumption authorized by instruction 6 with the presumption that my client is innocent, which is required in all criminal cases, as well as other presumptions that are listed in the instructions.
Have been different if
not based on our arguments. I think that would be a clearer case if the prosecutor had said you must presume, but I think that this case where it said you may presume is still impermissible.
The statute said you shall.
The statute says there shall be a presumption. There shall be a rebuttable presumption. The instruction in this case says you may infer.
I understand that, but we're talking about the argument.
Right. So in the argument, the prosecutor discusses the presumption, and I don't think that it would have been a different outcome if the prosecutor had said you must presume, because the prosecutor links it to the other presumptions authorized in the instructions, like the presumption of innocence. I think too,
Didn't read the statute.
that's true. So I think that this court needs to remember that the jury is instructed that arguments from counsel are not evidence. So there's a difference between what a jury receives in an instruction packet and what they hear during closing arguments. And that is important because we expect and trust that jurors follow the law. When a jury receives instructions from a judge that it may presume, without considering evidence provided by the state, an element of a crime, that shifts the burden to my client impermissibly. That's a problem in this case because the sentence difference for Mr. Strong is 12 and a half years. It is not too much to ask that the state prove every element of a crime when it seeks to cage a person for an additional 12 years.
Let's set aside the statute for a second. It doesn't exist.
Okay.
District court have been legally in error to have given the pick instruction.
The pick instruction is a statement that describes what a jury may do, but is not based on law. So without a statute, without a statutory basis, I would hope that that instruction would be objected to, and then we could talk about that.
Well, we can talk. I'm trying to talk about it right now. So is it legal or not to give the pick instruction? I mean, I think, in Justice Stiegel has described it as the pick instruction standing alone, the correct statement of the law. And I want to know whether, I'm assuming the phrase standing alone means without considering the statute. But so let's just assume that. Is the pick instruction legally correct?
I think that it is improper and should not be given, but is nevertheless legally accurate. The reason I think it should not be given is back to what I was saying about the difference between instructions that are provided to a jury from a judge and arguments counsel can make in their case. So in a world without the statute or a world without the instruction, a prosecutor remains free to argue, you should infer, based on the quantity of drugs found in this case, an intent to distribute. You should infer, based on the other evidence in this case, that these drugs were not for personal use, that they were being sold, that they were being distributed, that there was intent here. But that's different from a judge telling a jury, start with presuming intent, or you are authorized to presume intent. Instead, we should require the jury to examine evidence and actively draw inferences from that evidence based on the elements of the crime, the instructions from the judge, and arguments of counsel.
It sounds like you're saying that just because this is a correct statement of the law, or that it's not an incorrect statement of the law, doesn't mean that a judge should give it in an instruction, because that's essentially the court putting its thumb on the scale. And this really is appropriate as argument from the state. Is that a fair summary of what?
Yes, Your Honor.
You're saying it unduly emphasizes the jury's right to make input.
I think so, Your Honor. And the reality is that we tell juries, you can draw inferences, you can use circumstantial evidence, you can use common sense, you can look at things like weight or context or what else was found in the bag that included drugs. You can consider testimony from officers, you can consider the credibility of witnesses, but that doesn't mean that we should tell juries, we don't do this in other contexts. We only do this in drug cases where quantities listed in KSA 5705 are found. We allow juries and trust that juries do, and they do because we have convictions in cases that show it, draw inferences from circumstantial evidence in other cases.
So I take it if this instruction had merely said, you're permitted to consider circumstantial evidence when considering whether the state has met its burden on the elements of the crime, including intent, you'd be okay with that?
Yes, Your Honor. I think that is an appropriate instruction and is based in law, and I would have a much more difficult case if that was the instruction given.
Oh, go ahead.
That still gets me, taking back to before Jessica's question. I'm really not seeing how you can get to the facial challenge to the statute when there was not a mandatory presumption instruction given. I mean, the instruction under which your client was convicted was explicit.
Yes, so the instruction 6 frames the language from the statute in permissive terms, which is legally inappropriate, like this court has told us in Holder and Valdez.
From the statute, I mean, the instruction didn't use the word presumption, it used the word inference.
Right.
So I'm not really even seeing how, the 3.5, I think, came from the statute, but it's not the statute. So I don't see how you can say you're challenging the statute, which you rebuttable presumption, okay, which is mandatory, shall and rebuttable presumption, when the instruction under which your client was convicted doesn't use the word rebuttable presumption and doesn't use the word shall, but uses may and inference.
Yes, so Justice Standridge, my answer to that would again be the comments made in closing argument, the notes on use that are in the PIC pamphlet where this instruction derived from, as well as comments made in the instruction conference between counsel and the district court judge in this case.
That's not what your client was convicted. Your client was, when push came to shove, when they were asked to convict your client, it was under the jury instruction, right?
It was under the jury instruction following prosecutorial argument, equating instruction 6 with the mandatory baseline presumption of innocence. And I think that demonstrates harm in this case. The linking of those two, I think, is especially problematic.
In order to make that link, we must equate can with shall, correct?
No, because
you can presume, same as you shall presume.
No, because the prosecutors, I would distinguish that based on the use of the word presume. So the prosecutor is drawing the jury's attention to the word presume in the instructions, which, as Justice Standridge says, is not in instruction 6. The word infer is in instruction 6, but the prosecutor nevertheless elevates that to a presumption through his argument.
Was the instruction titled rebuttable presumption? I mean, I know you were here and heard the argument that happened just a few minutes ago, and Mr. Obermeyer actually held up a piece of paper for us, and I don't know whether it was the actual instruction given in that case, but it was titled rebuttable presumption.
The packet given to the jury was titled instruction 6.
Okay, so we don't have that issue here.
Correct.
It seems like you're making a but-for argument. In other words, but for the statute, we would not have had instruction 6, and we would not have had the prosecutor's argument. We need some kind of fact-finding on the but-for, or how do we make that determination?
Chief Justice, I see my time has expired. May I answer the question? Your Honor, I don't think that we need fact-finding. I think it's clear from the record and from the law and what we know about practice in this state, as well as comments made on the record, that this instruction is derived from the statute.
So if it is derived, which it is derived from the statute, but the jury doesn't know, but we still find under Holder and Valdez that it was legally not appropriate. Doesn't that end it here in terms of your constitutional argument? Why would we reach that if it's not legally appropriate? How do we get there?
So you can get there through standing, which we've discussed. You can get there because it's clear that the instruction derives from the statute. You can also get there because as long as this court doesn't address the statute, these instructional errors will continue, as the court knows from its docket. Holder was argued before this court in December of 2021. Here we are a year later, continuing to fight about the statute and instructions based on that statute.
Holder and Valdez really have taken effect, and hasn't there been some response to that by, since I would think at least there's been some response to it since we've ruled on it.
I hope
Just
so
like
as
this.
well.
Yeah.
I hope so as well. Those cases
Yeah.
haven't come back up yet, but I would hope so as well. May I have leave to briefly conclude, Your Honor? We would ask that this court finds that KSA 215705 is unconstitutional because it requires a mandatory rebuttable presumption in criminal cases, which impermissibly shifts the burden to my client. In the alternative, we would ask that this court finds the instruction was given in error in this case. Even if the court disagrees on those two issues, at minimum, we would ask for a remand for reconsideration under its opinions in Holder and Valdez.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state. I'd like to start off by saying I'm certainly a lot smarter than when I wrote the documents in my case, after having read some of the briefs, some more opinions, after hearing the court discuss the Slusser case. I think when we talk about the statute, 215705E, I don't think it can be looked at without looking at the 60-416 as Mr. Obermeyer was talking about. It's regrettable, I think, that the rebuttable presumption term was used in that statute. I know we say we can presume that the legislature was aware of case law and other statutes and stuff, and it doesn't really explain why they use that term. But I think when you look at the statutes 60-416, which are in the Code of Evidence, and you think about in this the Harkness case where this court and other cases said this rebuttable presumption was an evidentiary type rule, I think it comes into focus just a little bit what's going on here. And I think that with regard to 215705E, we have a situation where they've used this term rebuttable presumption. They've used the term shall. I do address the shall part in my brief a little bit, and I'll come back to that. But if you look at the evidentiary statute 60-416 and 15, it tells you that we can't, if there's these conflicting presumptions, you've got to go to the weightier one. And then what is more weighty in a criminal aspect than the right to be presumed innocent and the requirement that the state prove every element beyond a reasonable doubt? If that's true, then that rebuttable presumption language has to be subservient to that beyond a reasonable doubt standard.
You're saying 5705 is just a nullity?
I'm not saying it's a nullity, and that's why I'm saying that it's unfortunate that they the term was used in there.
Well, that's the entire statute.
It is the statute, but you have to look at the statutes together and
right. It just sounds like you're making the argument that because of the presumption of innocence, that effectively wipes 5705 off the books.
No, that's not what I'm saying. Okay, what I'm saying is it better explains what the legislature was trying to do. It's regrettable. Again, you have the prosecutor standing up in that Slusser case talking about rebuttable presumption when the instruction clearly was talking about a permissive inference type situation. I'm just saying if you look at the statutes together, the meaning of that statute is not the rebuttable presumption type language that this court gave it in Holder. It's not, it doesn't have that strength that we say, well, it's a rebuttable presumption. That means the jury has to presume that.
You're saying, I'm sorry to interrupt, but just your argument is that 5705 actually means permissive inference. That's what it means.
Yes. If you're looking at the statutes together and reading them and trying to make sense of what they're trying to say,
it's for that reason. And you had asked earlier, Justice Stiegel, about presumption, inference, assumptions. I think those are all three different things. Do people misuse them and use them interchangeably? Sometimes I would say maybe. To me, an inference means that's you're making some kind of deduction. A presumption is something that you might be doing based on a set of facts. An assumption is something that you're doing not necessarily tied to the facts. I think they're different. It doesn't mean that people aren't confusing those things, and it's kind of regrettable when we're talking about those in closing arguments or, to the court, that we're interchanging those. But to the layperson, do they really know much of a difference there? It's hard to say. I can't prove or disprove that. I do disagree with counsel in the respect that in our case, for whatever reason, the judge did not follow the PIC instruction, at least not a current one, probably pre-2012, I'm guessing. In our case, we actually had the use of the word presumption. We use presume and presumption. It's not infer or inference. We used the word may. We didn't use the word shall. My argument, as in my brief, is shall doesn't always mean you must, okay? Justice Standridge made a statement regarding just that. State would disagree. Looking at the context of the word shall, there's no penalty, there's no force requiring either the state to accept that presumption when it's arguing a case, or requiring a defendant or a jury to, or a defense to attack that or rely on that. It's there, it's a rule of evidence. You can use it or not use it, despite the word shall. I think if you go back and look at, in Kansas case law, shall is not always must. I would submit to you that reading it as a may in the context of what we're doing here is reasonable and proper in this case.
How do we deal with, you're asking us to rewrite the statute.
No, I'm not asking you to rewrite the statute.
You are. You're asking us to look at this statute and say rebuttable presumption doesn't mean rebuttable presumption. It means a permissive inference. Must or shall. Shall doesn't mean must. It means may. And the legislature, by passing this statute, has specifically dealt with the state's elements of proof in a criminal offense. I don't see how we get judicial reach to redo this statute the way you want us to.
I guess I'm not
on the notion that, well, there's, a presumption of innocence here. And so, any statute we find being unconstitutional, we should rewrite rather than, in the criminal context, rather than find it unconstitutional.
Justice Biles, I'm not asking you to rewrite anything. We have statutes that this court has found to be partially unconstitutional, and we've excised some portions of statutes. We've read statutes in the context of other statutes to make them harmonious. This court is under a duty to make statutes harmonious. All I'm asking is, when you're looking at this statute, that you make it harmonious. I'm not asking you to take anything out. I'm not asking you to do anything to it. But what I'm asking you is to step back from the notion that this rebuttable presumption means the defendant has a duty to do something that's contrary to Kansas law and the Constitution. My authority for that is 60-415, 60-416. Even if you step back into 60-414, I think this court addressed 6414 in Holder, and it talked about rebuttable presumptions, and if it was, I don't remember the exact terms, but if it was factual based, and the defendant would have a burden to prove otherwise. If it wasn't fact-based, that burden wouldn't exist. But these other two statutes, 6415 and 416, they make it clear that that rebuttable presumption that we're talking about cannot override our burden to prove guilt of every element beyond a reasonable doubt.
Counsel started off with a constitutional claim here. Would you please explain the state's position as in terms of what is the basis? What's the rational basis for the quantity and equating that with distribution that's allowed, that the statute defines? Where does that come from?
Are you talking about the 3.5 and where they came up with those levels?
That's kind of what's the basis for the
Justice
quantity?
Rosen, I just know from looking at the committee notes on that was dealing with this legislative issue back in 2010, I believe. There was some discussion prior to some of this presumption and levels that you were equating, there was no, it was if you were distributing a low-level amount, a high-level amount, the crimes were the same. This was a way for the legislature to come in and distinguish between low-level dealers, high-level dealers, and it gave them the opportunity to vary the punishment in the statute based on that.
Why 3.5, I think, is the question.
Right.
I understand what the purpose was. Why 3.5 is the place to draw the line?
I think that committee took, for lack of a better word, testimony from law enforcement people. There was reflected anywhere in the legislative history? Well, in the note, and I have the recommendations from the committee, and it could have been, and I don't want to overstate it, Justice Biles, but it could have been from the various people on that committee that were looking at this. We had, I know, appellate defender Deborah Wilson was on there. I believe we had some, the police, law enforcement engaged in that. I think we had some prosecutors in there. We had some legislators in there. There was a lot of talk about where do we draw these lines? And, you know, we had Senator Brattle was in there. Steve Opat was in there, Professor Stacy. So they had extensive discussions, and let me see so we're not doing this in a vacuum. According to the document I have, it's a House Bill 2668, quote unquote, cleanup and policy recommendations. I think this came from the legislation itself was requested by the Judicial Council based on the policy recommendations of the Kansas Criminal Code Recodification Commission. And then that was, out of that was the Criminal Law Committee from that. And I think that's what.
I mean, it seems to me you're just telling me that a bunch of talented people flipped a coin and came up with 3.5. I don't understand where the 3.5 is coming from, because all you're doing is just saying, well, these were a bunch of really smart people, and that's what they came up with. I mean, well, there's got to be some factual basis for this, doesn't there, as opposed to just flipping a coin?
I don't think it was flipping a coin. Again, Justice Rosen or Biles, there were people on that committee that were talking about that, and I don't recall all the details about what came in, but there were certainly people in law enforcement saying, you know, we've had dealers who were, you know, 3.5 and above, and then they made levels. I mean, your typical meth user is getting a single dose hit, using it, and going. They don't have multiple doses at one point in time, and I think that's where that's spawned from.
Do you guys charge intent to distribute if the amount is 3.0? On the notion that you can, yeah, I mean, just as a prosecutor.
As a prosecutor, without other evidence, I have charged something below 3 with evidence that they were dealing. At 3.5, I would also do that as well.
Is it automatic though at 3.5? And again, I know we're talking about prosecutorial discretion and it's doing this on the fly a little bit, but it seems to me that once that threshold is met, don't you typically charge with intent to distribute?
Well, it's certainly a possibility, but again, I don't want to take it down to that simplistic level that it's an automatic trigger. I think we still have to use our discretion with regard to how we do things, to be quite frank and honest with you.
I'll ask you something on a little bit different topic. The colleague mentioned that while it might otherwise be a correct statement of the law to the jury that you may make inferences from the evidence, did it unduly emphasize certain evidence for you may make inferences from a large amount of substance, 2.5 or more?
And your question is what if?
Does that unduly, is it error because it unduly emphasizes certain evidence? The same as sending a transcript in of one person's testimony to the jury.
I don't think so. I mean, in a drug case, the whole question is, when they come in and say, well, we possessed it, but we didn't possess it with intent. I think a directed instruction, I don't think there's any error. I mean, it's definitely hitting the heart of the matter when we're talking about the drug possession.
But you're not emphasizing the fact that he lied about being cooperating with the DEA agent. You're not other things that were testified about.
Well, I guess in context, there are a lot of statutory presumptions that we, in Kansas statutes that this court has addressed. And I'm
talking about, I'm sorry, aside from the statute. Aside from the statute, it's a colleague mentioned, it's a correct statement of the law that the jury can make inferences from circumstantial evidence. That's not from a statute. That's, I guess, common sense.
Right.
But is it error if you emphasize that they may make inferences from certain evidence, such as the weight of the drug?
I don't think so. I think, again, I'm not sure what the distinction would be. Under your scenario, as a prosecutor, I could stand up without this directed instruction, and I could say, you can infer from the 3.5 amount of drugs that this person was distributing. So what would be the difference whether the court instructed that or didn't instruct that? As long as the state is doing what it did in this case, is we still have the burden. You can accept or reject the presumption. To me, it's where does the argument lie? And if there's some kind of weight that's supposed to go to this because it's in an instruction, I have a hard time getting there as far as if we're going to talk about reversible error, and are you just merely asking about error itself? I don't think so, and I certainly don't think it's reversible.
Counsel, I know you're out of time. I want to ask. This is really just the big question that's bouncing around in the back of my mind during all these arguments. And I think the best way to ask it is, why should a jury ever be able to presume any element of the state's case, no matter what? Whether it's a permissive presumption or a mandatory presumption, rebuttable, not rebuttable, why should the jury get to presume at all?
And you don't care whether it's an inference or a presumption.
No, I'm asking about a presumption.
Presumption.
I mean, the word presumption literally means to take or to judge beforehand. The best English translation might be to take for granted. So why should a jury ever be able to do that with an element of the state's case?
Well, I think, number one, from where this court stands in 2022, almost 2023, criminal law throughout the state of Kansas and the United States has indicated that inferences and presumptions are an integral part of the law that are appropriate. The question is what do you do with that, and how do you prevent error? And that safety net is telling the jury the burden never goes to a defendant, that the state has the burden of proof.
You think those things are adequate protections that enable the state to tell the jury, you can presume these things?
I do. And apparently the U.S. Supreme Court and this court in the past has felt the same way about many of the presumptions. As I was stating earlier, I mean, we have presumptions throughout Kansas law, and the notion that this court would find that a presumption would somehow be reversible error in that respect, this court would have to take up and think about all the other rebuttable presumptions or presumptions that are in the statutes, probably 20 or more of these things.
Well, let me piggyback on what Justice Stegall just asked. In this case, there was evidence of distribution based upon not only the weight, but the weight doesn't have this magic 3.5 that the inference allows. There was more than that, and an officer testified in his experience what that weight could infer. What there were 15 to 20 clean baggies found along with other baggies. There was dividing up of the substance. Why isn't that enough without an inference to argue that this was distribution? I guess I don't understand why you need the inference, or what its function is in a case like this. And
the best I can tell you is it's not my choice. It's the legislature. And going to what Justice Biles had previously mentioned about, was this a correct statement of the law, and is it something that we can do? And I think it's yes. And the reason we're doing this is because the legislature tells us that we can do it. I think there's a case law, historical case law, that allows it. Chief Justice, I see that I'm out of time.
Loudon, I have a question that has been submitted by Justice Wall. Knowing that the jury instructed on something closer to a permissive inference here, how is there a conflict between the statutory presumption and the presumption of innocence? In other words, why can't these presumptions coexist, given how the jury was instructed, presumption of evidence? But if the state proves predicate fact, then reasonable inference can support the verdict.
I'm trying to put that in context. I guess it almost sounds like what I was advocating earlier, where they can coexist in the fashion that I mentioned because of the statute. We're not making this out of whole cloth.
I think what you had said earlier was that the presumption of innocence would always trump. And then Justice Stegall said that the other statute would be meaningless.
Right, and I don't think it is meaningless. I think when read in the context of the other statutes that it still is put in perspective. And I recognize that that may be at odds with what this holder. Valdez, thank you. With regard to what that rebuttal and what other case law there is on what a rebuttable presumption is, it's unfortunate that term was used, because I do think that has caused some issue. But I think if we put it in perspective, along with the other statutes, I think there can be a finding that this statute is not unconstitutional on its face. Thank you. Chief Justice, Justices, I just ask that you review these cases. I think looking at any single case is maybe going to be a little bit inadequate, looking at all the cases that you have before you. I think what should lead this court to find that the statute is not unconstitutional. And then with regard to this particular case, I think that the jury instruction given, along with the evidence in this case, that there was no error in the instruction. If there was error, it's not clearly erroneous. We'd ask you to affirm the conviction in this case. Thank you.
Unless the court has questions, I'm prepared to waive rebuttal and request a remand for a new trial where the state has to prove every element of the crimes Mr. Strong is charged with.
Can I just ask you the same question I asked your opposing counsel, which is just, should a jury ever be able to presume an element of the state's case?
No.
What would be your response to counsel's suggestion that would throw our criminal law into chaos because there's so many presumptions?
I disagree, and I think it goes back to our conversation earlier that a prosecutor, the state, is still free to argue. The evidence shows, circumstantial evidence indicates, a jury is free to make inferences from that evidence, and those are permissible, and we've known that a long time.
So it hinges on the difference between a reasonable inference and a presumption.
Yes, Your Honor, and I think that's clear not only in these cases, but in the cases that give rise to this issue, which are Francis v. Franklin, this court's opinion in Allen, this court's opinion in Harkness, and their prodigies. Thank you.
Thank you. Thank you to both of you for your arguments this morning. The court will take this matter under advisement.